celebrating our 20th season. From the college by the lake, meeting the personalities and discussing the issues that affect all of Coeur d'Alene and the inland Northwest. We are the North Idaho College Public Forum. And now, here's your host and moderator, political scientist Tony Stewart.
Today we have a very important subject to discuss with you. We're going to talk about sexual harassment. There's been a lot of attention given to that. It's been a problem a long time, but with some national and regional issues that have taken place in recent months, of course, it's gotten the attention of the people of this country and also programs such as the one that we have. I cannot think of more qualified individuals in our region to discuss this very important topic than our guests today. I'm very pleased to welcome to the program two attorneys that practice in Coeur d'Alene, Idaho. First of all, I'd like to welcome Ann Solomon, who's practiced law for a number of years and has also been very instrumental in the issue of conflict resolution and is one of the founders of that center. Ann, welcome to the program. I'm equally delighted to have on the program Ida Leggett, who is also an attorney and has certainly practiced law in a number of areas, but this is certainly one that she has addressed with some of her clients and her personal interests. And Ida, welcome to the program.
Thank you, Tony.
And as always, I'm very happy to have regular panelist Janelle Burke, who is also an attorney and is the law clerk to the one of the district judges in North Idaho. And with her background, Janelle is highly qualified to address this very complex and very important issue. And at this time, I would like to ask Janelle to commence the questioning.
Ida, let's begin with you for the questions today. What is the basis for a lawsuit in sexual harassment?
The basis is founded in our law, constitutional law. There are federal statutory law. There's state statutory law and some general constitutional provisions. In Idaho, one of the things that's developing now is that some employers also, as part of their employee manuals, define sexual harassment, when it occurs, and what their duties are, so the cause of action can spring from all of those sources.
So it could actually be a contract cause of action as well, rising out of the employment contract.
Yes, and as I say, in Idaho there is a body of law which states that if you have an employee manual and if both the employer and the employee resort to that manual to determine what those rights are, they then have a contract, even though it's not in the classic term of what a contract is. And in recent times, since the early 70s, some larger employers have begun to include sexual harassment as one of the improper acts in the workplace.
But apart from that, if you're the employee of a small business, you might be looking to federal law or you might be looking to state provisions. Is that correct?
Exactly. The federal law is both, as I said, both constitutional protections as well as civil rights protections. Title VII has to do with individual rights, including gender-based discrimination and harassment and those kinds of things. Idaho has a statute which put in place the Human Rights Commission, which deals with all of those issues, deals with race, handicap now, and sex discrimination.
And is sexual harassment something that's new, or is it something that's always been with us? That's the first part of the question that I have. And the second part is, who can be sexually harassed?
I would say that sexual harassment is probably not new. I think that the attorneys haven't had many experiences with it until more recent times. The first case, I've been practicing 13 years, and the first case that I heard involving the issue was probably 5 or 6 years ago, where a woman complained about very serious, real intimidating acts being conducted against herself by her supervisor at the workplace. And that was the first case that I had heard about it. But I would say that there's been increasing awareness of it due not only to the Thomas versus Hill hearings, but just in general with an acceptance of what's okay in the workplace and what sort of environment is productive in the workplace. And the second question you raise is a very good question and really should be emphasized, and that is there might be a preconception that it is a male supervisor, for example, doing acts which threaten a female person under the supervisor, but that really is not always the case. One case that I have read involved a male supervisor doing things to a male employee that were really unacceptable. And of course there's that implication that might have to do with the sexual preference, but it really doesn't. It isn't limited to that. It can be any behavior, female to male, female to female, male to male, and then of course male to female.
And it can also be at the supervisory level, but it can be with co-employees too as well, isn't that correct?
Absolutely. It has to do with the environment, the behavior that affects a person's work attitude and their productivity in the workplace.
As you indicated from some of the issues that have arisen, or this issue has arisen in some really publicized cases lately, there is a real interest I sense from talking to people, employers and employees, to be very clear and specific. And I know it's like other areas of law, as you are plowing what we call a somewhat new areas as far as what you're talking about and the history. I think it could really be helpful to our viewers if we could bring those individuals up to date about, in your practice and the legal process of defining what is sexual harassment. What kind of definition do we look for when you're in court and someone is charged with this, or if you're preparing a contract and manual, how would you define sexual harassment?
Now, Ida, you chime in here. I would define it as uninvited and unpermitted behavior. And the reason why it's not clearly defined is because it will vary so much with the environment. Some people, when I have spoken with groups before, I have used the peer response in groups. For example, blonde jokes. Many people find those terribly offensive. They don't offend me very much. I don't know why, whatever. But if you're in an environment where there is a lot of sexual innuendos, a lot of jokes which are really offensive, a lot of touching and hugging, and that's not okay with a worker, then that conduct has to stop. And that's how I define it. If it's uninvited, in other words, you might have a situation where two people within a workplace really like each other, are attracted to one another, and end up in a relationship, maybe marry even. I mean, that's certainly not going to be prohibited, but if there is advancement from one to another that's not wanted, and after the word no is used and the advancement continues, and if it's tied to anything having to do with work and affects productivity, then that's getting into an area where it constitutes sexual harassment.
And I'd like to also ask Ida to expand on that. In relation to Ann's very articulated definition, if it also, when it's a supervisor and an employee, if that particular advancement of sort is being used, that if you do not consent, that then your job is threatened, or advancement in employment. Isn't that another area that we should?
Yeah, sexual harassment, there's a broad spectrum of what kind of conduct can constitute sexual harassment. On the high end, and the one that's easier for people to understand, we have that harassment that either you submit to my advances, or you will not get a promotion, or you will be transferred to a less desirable position. People can understand.
Or in some cases fired.
Fired, yeah. That's easily understandable. The kind of cases that I'm involved with now, and some of the cases where there has been litigation in, are those cases where it's a lot more subtle than that. It's cases where there is a pervasive atmosphere of sexual innuendo, as Ann stated, jokes that are unwelcomed, practices that are unwelcome, such as posting of offensive material, reading of offensive jokes, and the like. The few cases that we have, is stated that when that kind of conduct, that activity, reaches the level where the workplace, the environment in the workplace is hostile, intimidating, and I'm not sure whether the word would be uncomfortable, but offensive, where there is an offensive atmosphere at work, that's harassment. And that's a lot more subtle, it's a lot more difficult to prove, it's a lot more difficult to articulate, and that's one of the problems in this area of the law.
This is so important, and you're both doing such an outstanding job, but to take this a little bit further for expansion in our understanding, I was watching another program, a television program recently, in which it was suggesting, that program, I'd just like to get your reaction to this, is that if someone is engaging in a behavior that it's really not clear where that line's being crossed, one of the pieces of advice that was given is that a person should really feel free to say to another person, am I doing anything that's offensive, that it's very legitimate to ask that question. How would you react to that recommendation?
And that's one of the things that I advise my clients. And, I have clients on both sides of this issue. If an employer is uncertain whether permitting other employees to post certain notices or certain jokes is uncomfortable, he should or she should talk to the people involved. Is this making you uncomfortable? Should I stop this? And also on the other end, if a person has been subjected to that kind of conduct and they're not sure whether it crosses the line, the safe thing to do is say, go to the person who is causing this activity and say, look, this is uncomfortable. It's making it difficult for me to perform my job. Would you please stop?
One final,
yes, please. Excuse me, and I agree with Ida, because in the end, a panel of our peers of 12 people decide yes or no there was harassment in the workplace. Or if it's not a jury case, then it would be tried to a judge who is, again, going to be one of our peers. So if it's unreasonable to 12 people on the jury, then I think it's a good policy to ask your peers in your workplace.
I have one final question before going back to Janelle. And this is not unique to this particular area of law, it's in some other areas too, but I certainly have read about this recently, that when you do go to trial in a case like this, that I understand in the overwhelming majority of cases, both the plaintiff and the defendant, about whatever action takes place, that many times they're the only two persons present when the alleged incident takes place. And is that a great dilemma for you as an attorney and for the court, all the decision makers, the jury, to decide who is telling the truth?
Oh, it's the toughest thing. I think it's the toughest thing in the law, really. And you just can't imagine how the stories can be so diverse. You just can't. And so to me, I tell my people, you have to make a decision when to report. The risk of reporting up to a supervisor or up above the supervisor, if the conduct is by your immediate supervisor, the risk is you'll lose your job. But on the other hand, it's then documented, and once notice is given to the employer, then the employer has an obligation to prevent the recurrence. Without notice, then the employer technically has no liability, because person cannot be liable for what they don't know is happening. So.
Yeah. One thing too that's a little bit different. A lot of the cases do have one person saying this happened on this date, another person saying no, it didn't. I've had cases where one person said this happened on this date, the other person said yes, it did, but there was nothing wrong with it. Those cases are easier.
They are.
Quite a bit easier. Then it's up to the jury, as Anna stated, to decide whether what this person did actually meets the court's definition of what harassment is. Employers and other workers are now becoming a little bit more sophisticated now. Now they're in the stage of, no, I never said that, rather than I said it, so what? That kind of thing.
Janelle Burke.
Well, I would like to start with Anne, and then we'll move to Ida, and ask Anne, what really are the difficulties that someone who is a victim faces? I want to deal with the victim a little bit more yet before we go over to the employer-employee situation. But at this point, what really are the difficulties that a victim faces when they decide to pursue a lawsuit? And then Ida, if you could tell what some of the defenses are that might be used against that victim.
Okay. I would say that the biggest difficulty is the ordeal of proceeding with a claim. It's terribly stressful, no matter what side you are on, to have to use the court as the system for resolution. And it's also very expensive and very time-consuming and emotionally draining. The second difficulty is, again, your credibility would be attacked. It's the cases that Ida and we're all are talking about, where someone might deny it, and in which case you may or may not have a witness. And the third thing is, in many cases, I believe that the character of the person alleging the incident is subject to attack. It becomes a personal thing. One case that I have read went into great detail about the relationships of the female. It happened to be a female who was making the allegation, and that became a personal attack on her. Did she invite the conduct? And that it became basically a trial involving her behavior. And it focused on her behavior really then more than the behavior of the person that she alleged. So those are, in my mind, those are probably the biggest difficulties.
Those are very practical difficulties, and now that's really bridged into, Ida, what some of the defenses are that the victim can expect to be used against her.
One of the defenses, one of the primary ones that I've seen used is that this employee was not a good employee. We had problems with absenteeism, we had problems with poor work performance, and that this allegation is just a ruse because that person knows that their job is in jeopardy because of their performance. Another prevalent defense is that she participated in it. Mm-hmm. It was not unwelcomed, and that there was no problem with this conduct until she then found that she had some other difficulties. She was going to be demoted. She was not going to get a raise. And having participated in it for X number of months and years, now she's just using it as a ruse. And then the basic primary defense is, no, it did not happen. There have been no complaints in the past. Here's her personnel file. There have been no documented instances in the past where this has happened. And if we had this conduct had happened, because of the way we keep our records, we would have a record of these complaints. We would have a record of others. And she's the only one. Everyone else is happy. Those are basic defenses. And those are basic defenses that work in swaying a jury. Now, one thing I intended to mention before is as to who to believe and what that standard is. There is a case in Seattle back in June, and I won't go into the case name, but in that case, a federal judge said, rather than using the old reasonable man standard to decide whether the person's conduct in response to that conduct was reasonable, we're going to use a reasonable woman standard when the victim is a woman, which is totally different. It hasn't been reviewed yet, and I'm not sure how long that's going to stand, but that's something new, and that's something that would help in making that initial decision about whether to file a formal complaint or not.
I'd like to follow up on that because before we did the program, we were discussing this. That's one of the advantages we have prior to going on the air, to have some detailed discussion. You mentioned some case law and cases that you were looking at, and some of them very recent. For our viewers, what are the courts saying, especially on appeal and defining all of this? Are we getting, I know you've already done a fine job of defining what you believe sexual harassment to be, but are there some points of law that is helpful to employers and employees?
Yeah, I think it's really clear, and I think Ann can agree to this, that no more is there a requirement that there be some overt act, some physical touching, some intimidation, either submit or you lose your job, or go out to dinner with me and I can give you a promotion. The cases now are saying that this atmosphere, this environment, this work environment, and I use the example of the posters, scantily clad women, and I'm using women because basically the way the law is now, women have been the victims. Instances where there have been unwelcome jokes or practical jokes or definitions, and the examples I want to use. I want to stay away from a lot of examples because I have an ongoing case now, and I'm trying to stay away from that. But the case law in other jurisdictions has been coming to the point, or is coming to the point, that these more subtle forms of harassment are being recognized as being actionable.
And Ann, would you like to add to that?
And I would say, too, that I have read some cases where an act which is very provocative, for example, one case, a male employee pinned a female against the wall so that his entire body touched hers and attempted to kiss her. And the court found out that that one act was not sufficient in and of itself. So it goes both ways. Like Ida's saying, the court is now looking at the whole environment and the environment that the employer knew about. And a single act of asking for a date, or a single act of attempting, for example, losing all your control and attempting to kiss someone, that single act will not be sufficient, I would say, as a general rule. But instead, it would go more toward the entire environment.
So we're hearing from you, too, that if there's a history and there's a pattern, then the case is stronger than if there's one incident that you can refer to.
Yes.
Another area I'd like to get into, and it's a cultural issue, and I think that this comes back to that, the mores, the customs and traditions, and how sometimes difficult that is to change, but it really is at the root of the issue. I recently was listening again to another program, and one gentleman made the statement which was extremely, I guess would say offensive to me, would be the best word to use. He was obviously not very supportive of dealing with this issue of sexual harassment, and he was indicating, to show a bias, a gender bias, that when some women came to work, it's the way they were dressed, and by their dress they had led this into happening. How do we get past those kind of cultural biases that say that, and it's a double standard for the genders, is that somehow that women don't have the same freedom as men? Is that what it's saying? And such things as stress or the issue? How would you respond to his comment?
I would respond that it's a very realistic comment, and it's maybe sad, but in my opinion it is true that, again, if you place in front of a jury of your peers that there is an individual who comes inappropriately dressed. For example, if the evidence at the trial shows that most women are dressed conservatively with blouses up to the neck and nothing provocative except one particular individual who may herself tell jokes, who may herself do touching, who may herself do dress with very, for example, high short skirts and low, then that may lead the jury to disbelieve her testimony. And it's probably sad but true. But to me, it's not an invitation. But that's the legal part of me, and just the human part. That someone, how they dress, does not invite immoral or inappropriate conduct. But a jury may disagree.
Yeah, and I agree, and I think we were talking before, Janelle. Those kinds of defenses, where she was provocatively, I can't say the word, she was dressed in that manner, so she invited that she must welcome those kinds of advances. Those are the same kind of defenses that were used in the 50s and 60s and early 70s against rape victims. She invited it. Well, my response to that, and I would hope that I'd be able to get an instruction from a court to the jury to say that no person invites the violation of their rights. And we haven't, and there's been no case law in Idaho, because this is a new area of the law in Idaho. There's been no case law that said that type of instruction would be proper, but I would certainly ask for one.
Janelle Berg.
Well, I want to also approach this problem from the employer's perspective. Suppose that we have an employer here and he finds out or she finds out that one of the other employees have been harassing someone. What would be your advice to the employer then? Let's start with Anne and move on to Ida. What kinds of things would you say they should do?
I would say that they, number one, should document the date of the notice. They should document and make an effort to keep an eye on the person doing the allegation and the person being charged. If at all possible, separate them so that, or do some sort of constructive acts to show that the employer does not condone a continuation. And I would advise them to send out notices so that it is in writing, that everyone then is on notice that certain acts are prohibited. Post them. Update a manual if there is a manual, so that then the employer has a basis to discharge anyone who continues to violate the policy. And
the only thing I can add to that is confront both the person who's making the allegation and the person against whom the allegation was made, and investigate that allegation, and if appropriate, mete out some discipline, depending on the circumstances and the gravity of the circumstance.
And if I'm an employee and I know that this is going on, someone else is being harassed, what kinds of things can I do to make sure that I'm separated from any kind of allegations against me? And I'm talking now about the hostile working place, where there may be things going on with a lot of people. What kinds of steps can I take as an employee to separate myself from the actions of others?
It's very, very difficult. It's easier for the employer to fix it than for the employee. Because again, as Ann stated, when you make allegations such as these, you're leaving yourself open for the ultimate sanction, which is losing your job. The first thing that I advise my clients to do before we even talk about filing claims or do anything is to contact or get in contact with the person who's actually involved in the conduct and say, please stop. it's not proper, I shouldn't work this way. That doesn't work. The next step is to go to that person's supervisor. If the person who's involved in the conduct is the supervisor, then you go to the next step up. If there is no next step up, then you have to make it very clear. I would like to have this stop. I know this is something that you're accustomed to doing. I don't have to work this way. And give them a reasonable period of time to try to conform their conduct. If that doesn't work, then you have to seek outside counsel and or contact the Human Rights Commission to see if they're, and the Human Rights Commission is good in Idaho because it acts as a mediator between the victim and the alleged actor.
If I could just interject here too, we've talked a lot about Idaho, but our viewers in other states, the state of Washington has the Washington Human Rights Commission, and there is also one in Montana. That's the areas that we look at most. So there is a very definite mechanism in place. I am familiar with Idaho's in the sense that then the commission, Ida, would, once getting the complaint, there are obviously forms I'll fill out, then they would contact the employer and they work in this relationship prior to any possible litigation, do they not?
It's not necessary. You can go there in Idaho, and I'm not sure about the Washington statutes. I have a Washington license, but I don't practice over there, so I'm not up to date over there. But the commission is one alternative. It is the least intrusive alternative because when you start getting attorneys involved, and you end up going to court. So in Idaho, you can go to the commission, have them act as a mediator to try to correct the situation, realizing that they have no subpoena power, or you can, go the route of the court system.
And Ann, we've heard the director of the Idaho Human Rights Commission, who's a good friend of mine, indicate to me that there was a real increase in cases because of some of the national publicity in our state. Where do you see the future? Do you see more cases coming forth, or do you see society becoming educated in the process so that behavior will change, or is it a combination?
I don't know. I would say that I have not seen more in the past 3 or 4 months. I haven't had many more calls. I think the awareness is exponentially increased since the televised hearings of our newest Supreme Court judge. But I have a feeling that there is also going to be an awareness of what's accepted in the workplace. I don't believe that employers want this kind of trouble. I believe that once people are aware of what's acceptable, that they'll make it stop.
We're out of time, I get the signal, but I want to stop by saying it sounds like the bottom line is be sure you don't continue behavior when the other person says it offends me, and no.
Yes.
Thank you both for being with us today,
You're
and Janelle,
welcome.
thank you for your fine questions. Ladies and gentlemen, I know you found the program very informative, and I'd like to invite you to be with us again next week at the same time when we will discuss an important issue. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Telemedia Services on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.